Namaskar, hello and welcome viewers. You're watching this special presentation of Sansad TV, Bills and Acts, where we analyze bills that impact you, acts that empower you, and programs that matter to you. I'm your host, KRITI MISHRA, and today the spotlight is on the Digital Personal Data Protection Act of 2023. In a significant step, President Draupadi Murmu gave her assent to this bill on August 11, 2023. Before the analysis, let's take a look at the highlights. There will be processing of digital personal data in a manner that recognizes both the rights of the individuals to protect their personal data and the need to process such data for lawful purposes. The Act enhances the ease of living and the ease of doing business in India. The Act also enables India's digital economy and its innovation ecosystem. And for deeper understanding of this Act, I'm joined by a very special guest. Please welcome Mr. RAJEEV Chandrasekhar. He is a member of the Union Council of Ministers and holds twin responsibilities as Minister of State for Electronics and Information Technology and Skill Development and Entrepreneurship. Welcome, sir.
Namaskar.
And also in the studio, we have a very vibrant mix of audience, students, lawyers, privacy professionals, cybersecurity professionals. Mr. Minister, these inquisitive minds have a lot of questions, volley of questions to ask. But just to set the tone and tenor of this discussion, Now, India's digital economy is expected to hit $1 trillion by 2030.
Correct.
This is a very significant law, first of its kind. But what does it mean for us as data users for digital nagriks?
So Kriti, I think you said it correctly. I think this is a very important piece of the overall framework that the Honorable Prime Minister is building in terms of laws and rules and regulations for this $1 trillion digital economy goal. The Honorable Prime Minister just 2 years ago on Independence Day referred to as the India Decade. The Digital Personal Data Protection Bill is a very important bill because for many years, citizens of India have had platforms take their personal data, ostensibly to use it to deliver a service or a product, but also to misuse and exploit that personal data. And many thousands and millions of Indians have found themselves on this side of the equation where the platforms without any accountability have misused their data and exploited it. This Digital Personal Data Bill codifies, or in a sense grants to the Indian citizens the rights to making sure that their personal data that they have given to a platform is protected and is only used for the purpose that it was taken for. So it is a very important bill. It gives the rights to the digital nagriks. And as you know, in India, there are about 83 crore digital nagriks today. And by 25-26, it will be 120 crores. So therefore, this is a very important part of a legislative framework that the Honorable Prime Minister is building that gives the citizens rights vis-a-vis the platforms that consume their data.
Absolutely, sir. And it's all about our rights. It's all about empowering the citizens.
Absolutely.
We are the biggest stakeholders. And also in the studio, we have with us very inquisitive minds. Let me open the floor. Let's take their questions.
Okay.
Please go ahead, introduce yourself and speak your mind.
I'm Indrajit Singh. I'm a cybersecurity expert and a co-founder of a India Blockchain Forum. Really, congratulations to you and Prime Minister for a wonderful act. And this is going to change the whole dynamics of the way we live in the digital world. So one question is that while we have the IT Act 2000, what are the ramifications with the cyber crimes rising and the Data Privacy Act coming into force now, sir?
Look, if you remember, the IT Act also deals with data protection and privacy, but does so in a very asymmetric manner. And I'll explain to you what that means. In the IT Act, which was the formulation prior to the Digital Personal Data Protection Bill, the user had to prove that harm had been caused to him or her by the breach of data. So therefore, if your data had been breached or misused by any platform, it was incumbent on the user to go to court and prove that I had been harmed or there was a consequential harm to me before the platform would be held accountable. In the Digital Personal Data Protection Bill, that has been turned on its head. And this is very aligned to Prime Minister's vision that the citizens must have the right, and it is for the big platforms and the big business to prove that no harm was caused in the event of a breach. So in the Digital Personal Data Protection Bill, if you as a citizen have given your data to somebody and that person misuses it, exploits it, or the data is breached from him, automatically you can hold him accountable under this law. So therefore, there is a very, very deep asymmetric inversion of the asymmetry that existed in the IT Act and brings back a level balance between the rights of the Indian citizen and the obligation of the platform.
And the Digital India Act, which you're also likely to bring up in another couple of months, I believe so, is going to dovetail all these factors into account and make people responsible and people who are criminals behind the bars at the shortest period of time.
Look, the broader discussion that you are having today, or the broader question about user harm in general, and you know in cyberspace there are so many new user harms that are not there in the real world. Cyber stalking, doxing, gaslighting, there's so much of cyber crime that are innovating and building, coming from all over the world. We are going to address all of those comprehensively in the next big part of the framework that the Prime Minister is building for the India Decade, which is the Digital India Act.
Right, sir. Let's take another question now. Yes, young lady, please
Hello, good
introduce
afternoon,
yourself.
sir. My name is Arushi Agarwal. I'm a student at King's College London. I'm currently studying politics. And I just wanted to know, with data being a key driver of innovation and economic growth, how does the Act encourage a collaborative environment between the government, industry, civil society at large to ensure responsible data usage while also fostering technological advancements?
So first of all, I want to say this to you, that there is no incentive anymore for responsible behavior. There is a law. So nobody is asking the platform with folded hands for responsible conduct vis-a-vis personal data. The law makes it very, very clear for platforms that if they don't conduct themselves responsibly, there will be punitive consequences of high penalties. So it is no longer a question of saying, look, please act responsibly. It is now the statement that this law makes is Indian citizens at large have certain rights. And this law enshrines those rights, allows companies in the data economy to conduct themselves responsibly and do well. But the moment they breach the line or breach the law, there will be consequences.
My name is Ankur and I'm a chartered accountant by profession and also a privacy professional.
Sure.
So as a privacy professional, we have been monitoring the developments around this area and we are quite happy to see finally this act has been able to see the light of the day. So one area where we have been interacting with a lot of companies outside India as well is that globally, the GDPR regulations, the General Data Protection Regulations have been there for quite some time now. But now in Indian companies, probably they were struggling because the law was not there in terms of the compliances. So do you foresee that in near future, there would be some kind of a marriage between both of the acts and some relaxation would be granted to companies that are already compliant to a certain large extent under the GDPR regulations?
So first of all, let me just say that if you've been following this for long, I've been following for 13 years.
That's true.
So fair enough.
That's
so
true.
both of us are co-travelers on this journey in a lot of ways. And I was telling somebody yesterday, I think a lot of things that we believed were impossible or difficult to achieve some years ago, I think with the clarity of our Prime Minister, those things are all being achieved today. So I think we are certainly in a different era and a different time. On the issue of what we call adequacy between the GDPR and the DPDP, look, first of all, let's be clear. The internet is a borderless space. And therefore, to create legislations that only work in a particular jurisdiction, while it doesn't work across, is really the way it is. Because the laws that we enact cannot be applied in Europe and vice versa, GDPR will not apply in India. But the way to deal with that is to make sure that at least democracies and open communities and open societies like us, Europe, USA, Australia, Japan, we all agree on a certain set of basic minimum principles vis-a-vis innovation, vis-a-vis our citizens' rights. Our citizens deserve safe and trusted internet. I think there is a global consensus today in the world that the countries around the world want to cooperate. Why it is important for India to take a lead on this, and India is taking a lead, is with 830 million users on the internet, India is the largest connected country in the world. China's internet is not the internet, as you know, it's an intranet. So on the global internet, India is the largest single community of users. So in a lot of ways, I would argue, and I will predict, that the laws and the protocols and the global understandings in the future are going to be led by India.
That's true.
Because we certainly have a lot more to gain from a safe and trusted internet.
My name is Dia Rungta, and I'm a computer science student at Ashoka University.
Good.
I had one question that how do you determine the act will strike a balance between protecting users' rights and also facilitating innovation for startups and companies, especially small-scale startups that, as we know, the penalties have been increased. So what will be the impact in terms of business
it's a very good
costs?
question, and I always say that this, if you believed that that was not possible, because a lot of people thought those were binaries, that protecting citizens' rights and creating an innovation ecosystem were opposites. A lot of people said that. This bill, if you read, proves to you that when a government is determined to do both, and do both in a very sensible manner, we are able to do both. This bill manages two seemingly contradictory objectives: protecting the citizens' rights and also creating a innovation ecosystem momentum. And this bill does that. But I must tell you that for small startups, we have created an exemption. That means we believe that in the early days of a startup, let us say I'm starting a company tomorrow, you are starting a company day after tomorrow. I can't start it, you are the one who will start it. We will certainly give you exemption for a certain period of time, till you are bootstrapped, till you reach a certain critical mass. And we will notify those rules, saying that as a startup, for an early stage startup, we will allow some exemptions.
Hi, I'm Gaurav Singhal.
Please go ahead.
I'm a chartered accountant and a law graduate. What I noticed in the bill, sir, was that there's a fair bit of cross-border data flow aspect in the bill, territoriality aspect of the bill, right?
Sure.
Which is pretty interesting. Do you see a role of the board per se, the board playing a role per se in overseeing this function, say through the consent managers or otherwise?
Now, look, there are 3-4 different things you've asked. The board really has been designed as an institution that will grow, build the jurisprudence and the best practices on how to address disputes between the individual or the business whose data has been given to a platform and the platform that violates that obligation to keep it safely. So the board has a very narrow role of adjudicating these disputes, creating a framework of law and jurisprudence that would then be followed by subsequently on what constitutes a very big breach, what constitutes breach that cause harm, what constitutes an incidental breach, therefore what should be the penalties. So we have laid out a broad framework. We believe that this jurisprudence will develop as the board acts. In terms of cross-border, and as I said before, we all use the internet. The internet certainly has no borders. So if I'm today accessing a platform, it is very possible that the platform is hosted on, or the app is hosted on a cloud that is based in the UK, or the cloud is based in New York, or the cloud is based in Hyderabad. So therefore, it is very, very impractical to cast these geographical boundaries or limitations to how data is processed. But what we have done in this bill, which is a different approach from how we started looking at this issue, is that if we find that there is a certain geography where there's a cloud or a data center, or indeed any other data processor, where this law is prevented from being enforced, or the rights of the Indian citizen whose data is being stored there is not being enforced, then we'll blacklist that jurisdiction. So we will start with a broad list, and as there are jurisdictions that we see are not safe for Indian citizens, we will blacklist them and say you cannot process the data there. So it's a very simple concept. We believe it's an elegant way to address the issue of safety and trust and the flexibility of cross-border data flow.
That's a very meaningful assurance, Minister. Let's take another question.
My name is Mahima Jain. I'm a lawyer by profession. My question is regarding the implementation of the Act. So, will that be done in a phase-wise manner where certain clauses will have an earlier enforcement date? And also, how would you suggest organizations and platforms should strategize for this implementation?
No, so first of all, let me say this, that it won't be like clauses will have different start dates and stop dates, but we certainly see that there is a need for a migration period because we are moving from one framework or one regime to a new regime. And that requires our platforms to adjust. They have to have their consent management framework. They have to have the consent form. So we will give some time for migration. We will certainly give some time for transition. We certainly don't want any disruption. We want the migration to be orderly. At the same time, while companies may say, I want 2 years and I want 1 year, we are also seized with our duty to ensure that the citizens get this right as soon as possible. So there are almost two compellingly contradictory pulls. And so we will look at phased manner for different types of data fiduciaries. So the big, sophisticated, big tech companies, we will say, you can migrate faster. Government, startup companies that may require a little bit more time to adjust, to adapt, to create their own preparation, we may give them more time. So like that, there may be multiple categories. But I don't see this as being a prolonged, long migration period, because at the heart of it, these are citizens' rights.
That's true.
And this government will not deny their citizens the rights that they deserve.
Absolutely, sir.
I'm Priyamvada. I'm a lawyer by profession.
Yep.
So as we talk, there are hefty penalties under the Act. But apart from that, are there any criminal liabilities as well? Like, can the senior management be held
No, under this
responsible?
Act, there is absolutely no criminal liability. We've designed it to be completely decriminalized. And we have created such hefty punitive penalties that they are punitive by nature. And as I say to people who ask me what the objective of this bill is, and I say two things. One is, it will put the brake on all platforms that are misusing and exploiting personal data. So that you have understood. The second is, it will cause a deep behavioral change because of the punitive penalties in the way platforms deal with citizens, deal with consumers, deal with businesses that deal with them as a platform. There will be a lot more responsibility and lot less recklessness, lot more accountability and lot less not my problem. So in that sense, I always point out that this money, these penalties are not for the government to make money. We hope that there will be never any penalty levied. We hope that no case ever goes to the DPB, Data Protection Board, because all the platforms read this law, get the message that the government wants to give them, that you must behave responsibly. There will be no problems if you behave responsibly, and the citizens will also be protected. So the idea here is with these penalties act like a deterrent, not as a money-making intention of the government.
Right, sir.
सर ये बिल अभी जब आई है, इसके
हाँ जी।
पहले भी गवर्नमेंट ऑफ इंडिया के पास बहुत सारे डेटा हैं कॉमन सिटीजन के, सामान्य नागरिक के, जैसे कोविन डेटा है, आधार डेटा है, मेडिकल डेटा। ये बिल उन जो भी पहले डेटा था उनको कैसे प्रोसेसिंग में हेल्प करेगा, उनको प्रोटेक्शन में हेल्प करेगा, किस एक्सटेंट तक ये बिल जो है, जो हमारे पहले के डाटा थे, पुराने डेटा था, उसको प्रोटेक्ट करने में हेल्प करेगा हमारी?
तो पहले तो एक चीज़ मैं बताऊं कि सरकार भी इस बिल के तहत अकाउंटेबल रहेगा। तो ये स्पष्टीकरण मुझे करना चाहिए और मैंने किया है। दूसरा, सरकार हो या प्राइवेट सेक्टर हो, डे ज़ीरो जब ये बिल लागू होता है, व्हेन इट गोज इनटू इफेक्ट, उस दिन हर प्लेटफॉर्म का एक ड्यूटी बनता है कि वो जिसका पर्सनल डेटा उनके पास है वो उनको सूचित करे। तो अगर मैं प्लेटफॉर्म हूँ और आपका डेटा मेरे पास है, 2 साल पहले मैंने ले लिया है, मैं आपको डे ज़ीरो में मैसेज भेजूंगा या ईमेल भेजूंगा कि आपका डेटा मेरे पास है, आप कंसेंट देते हैं या इसको डिलीट करें। तो डे ज़ीरो में एक तरह से नॉर्मलाइजेशन हो जाता है कि हर प्लेटफॉर्म के पास जो डेटा है या तो कंसेंट से आएगा या अगर कंसेंट नहीं है उन्हें डिलीट करना पड़ेगा। तो ये है मोटा मोटा द फ्रेमवर्क ऑफ कंसेंट। सेकंड, सरकार के पास जो डेटा है, सरकार को भी इस डेटा को बड़े संभाल के प्रोटेक्ट करना पड़ेगा और इसीलिए हमने 6-8 महीने पहले एक नेशनल डेटा गवर्नेंस पॉलिसी लाया है सरकार में, जो पूरे सरकार के अलग अलग डेटाबेस, पूरे अलग अलग मिनिस्ट्रीज एंड डीपीएस के जो डेटाबेस हैं उनको हारमोनियसली सेम स्टैंडर्ड, सेम प्रोसेसिंग स्टैंडर्ड, सेम स्टोरेज स्टैंडर्ड से वो सभी अप्लाई करें. So we are already prepared for it as a government, and we are aligned to the objectives of DPDP.
As per the Personal Data Protection Act, there section 34, there is no any provision for the compensation if someone has breached the data or violated the privacy of the person.
So what
हाँ,
about
so like I said, I think I answered that question कि यहाँ पे compensation और पैसा बनाने का सवाल है ही नहीं. तो इसका the whole idea of the punitive penalties is that it is punitive and it discourages companies from breaching. तो इसमें जैसे मैंने कहा, we expect, we hope that the message of the bill is that there should be no case ever referred to the DPB, and that there should be no penalties ever levied on any company because nobody will breach the data. This is our, and that is why we have made it punitive. And that is why this whole framework is a very different framework from what is in the original IT bill, IT Act, which talks about harm. Harm जब होता है, compensation का बात होता है. यहाँ पे क्या है कि you should not do it. If you do it, there is a penalty. So therefore, there are two different constructs.
If we gather everything at a single place, wouldn't it be easy to hack or steal? How you can assure people that your data is safe in our hands?
I would like to bring your notice to the section 28 and clause 12 that talk about at any stage after receipt of a complaint, if the board is of the opinion that the complaint is false or frivolous, it may issue warning or impose cost on the complaint. But there is no ground for that board take into consideration on which ground we think and opinion makes the board that the complainant is making complaint frivolously.
Over to you, Honorable Minister.
नहीं देखिए, look, let me address the first question first. There is nothing in the DPDP that says that all the data will be collected and kept centrally. ऐसा कोई प्रावधान नहीं है इसमें. हर डेटा का प्लेटफॉर्म, डेटा फिड्यूशरी अपने क्लाउड में, अपने डेटा सेंटर में वो स्टोर करेंगे. तो इसका आपका जो डर है कि सभी डेटा हमारे एक कीशे में हो जाएगा या एक कबर्ड में होगा, ऐसा कुछ नहीं है, और या एक क्लाउड में होगा, ऐसा कुछ. there's nothing in the bill that mandates all the platforms to collect data anywhere. They can do it anywhere they want. They can do it in their own hosted platforms or the cloud. So that, don't worry about that issue. On the second issue, please understand, as I said before, what we want to do, आप जानते ही हैं कि हमारा डिजिटल इकोनॉमी जो 2014 में it was 4% of GDP, today it is 10% of GDP, and by 25-26 it will be 20% of GDP. We are moving so fast on the innovation ecosystem, and we are becoming one of the world's fastest growing ecosystems for innovation. Now in that, the platforms have obligations that have been casted because of the rights of the citizen. But we certainly don't want citizens to get, or anybody, or vested interests, to try and create problems for platforms just by referring complaints. We want complaints to go to the DPB that are legitimate complaints. ये भी नहीं होना चाहिए कि DPB को busy रखने के लिए या DPB कोई business rival को busy रखने के लिए कोई notices भेजते रहे. So therefore, there is a deterrent for vexatious, you know the phrase, vexatious complaints. There is a deterrent here in the bill that says you should not do complaints to the DPB unless there is a breach.
Absolutely, sir. And I'm completely out of time. Of
Thank
course,
you.
there were several questions, sir. And as Prime Minister says that this is going to be India's decade, this particular act is going to be very, very significant and imperative in our digital march. Thank you so much for joining us.
Thank you for all your questions. Thank you very much.
Thanks a lot. Well, viewers, that's all we have for you in this edition. Thanks for watching and stay tuned to Sansad TV. Goodbye for now from my side.